Good afternoon to everyone attending in Europe, and for those of you joining us from North America, good morning. Welcome to the next instalment for 2021 of Contract Conversations. For those who haven't attended one of these before, this is a series of bite-sized, 20-minute long webinars being run by lawyers from across our firm to discuss issues that those involved in operating commercial contracts may need to contend with. So today we're going to briefly try and go back to basics a bit and look at some of the different types of contractual clauses that you have in a contract and typically what kinds of disputes can arise out of them. In particular, we're going to take a look at conditions, warranties, innominate terms, and then indemnities. And you may ask why it's important to know what type of term you're dealing with. Well, it's important because it can affect what kind of remedy you're entitled to if the other side breaches the term. So as we'll explain, the difference between these terms is particularly important when it comes to understanding whether you're entitled to terminate the contract if the other side breaches the term. And that can be really important in a wide range of contract disputes, since a lot of expensive and avoidable contract litigation arises out of disputed termination rights. So acting like you're entitled to terminate a contract for breach when you're not can be really expensive, because it will usually entitle the other party to terminate the contract and to sue you for damages for wrongful termination. So understanding how different contract terms are categorized by English law is important, both when it comes to drafting contracts and also when deciding what to do if the other side breaches the contract. So before we begin, by way of introduction, I'm Eric France. I'm a commercial disputes partner based in Mills Reeve's London office, and I specialise in commercial contract disputes of all kinds. And I'm joined today by Mark.
Hi, I'm Mark Davison. I'm the head of international arbitration here, based at Mills Reeve in our London office as well, and have a sort of similar broad background to Eric in terms of the sectors that we act across and traditionally in contractual disputes.
So very quickly before Mark kicks off, there's a Q&A function, so please do put any questions you have in there, either while we're talking or at the end. We've got actually over 200 people joining us today, which is great, but we'll try to deal with as many of your questions as we can at the end. If we can't get to your question, then we'll do our best to try to follow up with you separately after the webinar. Okay, over to you, Mark.
Okay, so the first type of term that we're going to look at today are conditions. And so put simply, a condition is a major term of a contract which goes to the very root of the contract itself. And so basically, if a term is regarded as a condition and it's then breached, the effect of that is that the innocent party is entitled to repudiate, basically bring to an end or terminate, as Eric put, terminate the contract, as well as actually claim damages for the loss which flow from that breach. And so the advantage of knowing if your clause is a condition is that you know where you stand. But one of the downsides is that no regard is actually given to the breach. What I mean by that, it's absolute. So if you breach a condition and the other side can treat the contract as repudiated, even though actually your breach was fairly minimal or it was trivial. The reason why breaches of conditions has this draconian effect is that so that parties can terminate the contract for breach of a condition is because it's deemed that the parties have agreed that that particular provision and the failure to perform it, irrespective of the gravity of the breach, is so important that it effectively should entitle the other party to choose whether or not to end the contract if it's breached. And I've just summarised there sort of a historic view of conditions there from the 1910 case there of Wallace and Pratt, as to why they regarded conditions as to be so important to the parties that effectively had this draconian consequence if there was a breach. Like with some of the other clauses that we'll come on to, clauses are usually in a contract given different heads or terms. And so just because the parties have called a particular clause a condition will not necessarily mean that the courts will accept that it is actually a condition. So when you're drafting your agreements, if there are some fairly fundamental clauses that you want to be treated as conditions, just take care when you're drafting those to make sure that you can clearly stipulate that it's intended to be a condition. In determining whether or not a term is a condition or not, the terminology used can be important because over the centuries, certain phrases have been held to denote the fact that the parties intended a term to be a condition. So say you've got a clause which gives a deadline for performance. If that clause says that time is of the essence, then the courts will almost certainly sort of interpret that as being a condition of the contract. Also, if you have a clause which says that if it's breached, it will allow the innocent party to terminate terminate the contract, then that will also help. Because of the draconian consequences that breaches of conditions can have, the courts have also developed another classification of contractual terms called innominate or intermediate terms, which I'll come on to. But just before Eric goes on to discuss warranties, I should just add that terms can be implied to be conditions as a matter of statute. So, for example, if you're dealing with sale of goods contracts in the business-to-business environment, then it's well worth just making note of the Sale of Goods Act 1979 and some of the provisions in there that imply that certain contractual clauses will be deemed as conditions.
Okay, so warranties are minor terms of a contract which are not central to the contract. So if a warranty is breached, the innocent party can claim damages, but can't terminate the contract as a result of the breach of the warranty. Now, the term warranty has been described as one of the most ill-used expressions in the legal dictionary because people use it to mean different things. It's often used in the sense of really any contractual undertaking or promise is just often referred to as a warranty, but it does have this technical definition in contract law, which is that a warranty is effectively the opposite of a condition. Now, even more super confusingly, in one branch of contract law, insurance law, the meaning of warranty and condition is actually reversed. So in insurance law, but not in the rest of contract law, warranties are representations of truth by the insured, which, if untrue, entitle the insurer to terminate the contract and treat it as at an end from the date of breach. So yeah, very confusingly, warranties and conditions basically have the opposite meaning in insurance law than they do in the rest of contract law. The emergence of innominate terms, which Mark's already mentioned, has actually meant that in reality, very few terms are treated as warranties. Really, the main point is that warranties arise where a term has been specifically classified as such by statute. For example, the Sale of Goods Act classifies certain terms and contracts for the sale of goods as either conditions or warranties. So a clause providing for when payment should be made is an example of a clause in a contract for the sale of goods, which is by statute deemed to be a warranty. In most other cases, a term which isn't classified as a condition will usually be treated as a so-called intermediate or innominate term, as Mark's going to explain now.
So, so innominate intermediate terms. So, as I mentioned, that because conditions can sometimes have fairly draconian consequences, what the courts have done is they've effectively developed the concept of the intermediate, the innominate term, to try and provide a more flexible approach to basically encourage parties to focus more on actually performing their contracts rather than discouraging. And so intermediate innominate terms, they're sort of a halfway house between conditions and warranties. And it all developed from a case called Hong Kong First Shipping in 1961. There's a citation there on the screen. And so what the court did there was, rather than classifying terms themselves as conditions or warranties, what the courts try to do when determining whether the clause is an innominate term or not is to actually look at what the effect of the breach is and then questions whether the innocent party to the breach was deprived of substantially the whole benefit of the contract. And it's only where the innocent party was substantially deprived of the whole benefit of the contract that the courts will construe that the parties can bring the contract to an end. So effectively what the court has done with the development of the innominate term is effectively come up with two classes. The first is that basically if a term is deemed an innominate term and then it's deemed so important that a breach basically deprives you of the whole benefit of the contract, then you can treat the contract as terminated. Similarly, though, if it's less important and it doesn't actually affect your enjoyment of the contract, if there is the breach, then you're not allowed to terminate and you can just sue for damages on the breach. So like a lot of commercial law developments, a lot of the cases on this area are from shipping cases. And the clearest test of how you construe whether or not you're dealing with a condition, with a warranty, or with an innominate term was set down there in the 2016 Court of Appeal case of Spa Shipping. And so what the court said there is that the approach should be that a term is an innominate term unless it's clear that it's intended by the parties that it be a condition or a warranty. And so in order to work that out, the court effectively developed this test, which I've put there on the screen, of basically trying to consider whether it's the intention of the parties that the term in question should be a condition, where the parties have not made the term a condition, again, that the term will effectively be an innominate term if the breach might result in trivial, minor, or very grave consequences. And the third element to it was that unless it's clear that a contract term is intended to be a condition or a warranty, again, it will be treated as an innominate term. And so when determining the SPA test, courts that have recently looked at the question have recently adopted the test in Wood and Capita on contractual interpretation in order to ascertain what type of clause that you're dealing with. And so in Wood and Capita, as hopefully as we all know, basically what the courts do is try to ascertain what the objective meaning of the contractual language is. And so it does that by considering the contract as a whole, and depending on the nature, formality, and the quality of its drafting, will decide whether or not to give more or less weight to elements of the wider context in actually reaching its view as to what the objective meaning of the wording in the clause means.
Okay, so moving on then to indemnities. Well, so far the difference between the kinds of clauses that we've been discussing is whether you're dealing with a clause that allows you to terminate the contract or not if it's breached, versus clauses that only let you sue for damages, in other words, for compensation for breach of the contract. But indemnities are different. They're a contractual obligation of one party to compensate loss that's been incurred by the other party. So they essentially create a duty to hold the other party harmless against certain specified loss. And the trigger for the duty to be indemnified can be anything defined by the parties in the contract. So it could be a breach of contract that triggers the indemnity, or it could be some other event altogether. So most insurance contracts, for example, are based on indemnities, and the trigger for the insurer's duty to indemnify in an insurance policy is usually the occurrence of some insured peril as defined by the policy. For example, a fire burning down your house, or somebody stealing your car, as happened to me just a couple of weeks ago. But that's another story. Indemnities are also found in other commercial contracts, though other than insurance, and one party can agree to indemnify the other party for certain losses if the first party breaches the contract, for example, by failing to deliver something on time. So for the claimant being able to claim claim under an indemnity has certain advantages versus claiming damages for breaches of the other kinds of contractual terms that we've been discussing. And the reason for that is really a sort of a point of principle, which is that when you're claiming under an indemnity, the theory is that you are calling for the other party to perform their promise under the contract to indemnify you, to hold you harmless. When you sue someone for damages for breaching a contractual term, then you're calling on them to carry out their secondary obligation to compensate you for breach of what was their primary obligation. But when it comes to indemnities, you're actually enforcing a primary obligation, their promise to do what they said they would do in the contract, which is hold you harmless. And so because you're enforcing a primary obligation, there are just a number of hurdles as a claimant that you get to skip past rather than jump over. So unlike a damages claim, you don't have to prove or worry about whether the loss you're claiming is too remote to be recoverable, which is the so-called rule in Hadley and Baxendale, which applies to damages claims that some of you may have heard of. You also don't have to worry about any duty to mitigate your losses. If you're claiming under an indemnity, you can just recover under the indemnity whatever loss is within the scope of the indemnity. And the losses that are recoverable under an indemnity may well be more expensive than what's possible under a damages claim. For example, you might be able to include your legal costs of enforcing the indemnity, whereas that's less likely to be recoverable in a damages claim. So it's for these reasons that parties often see it as an advantage to secure promises from the other side by way of indemnities rather than other kinds of contractual terms like the ones we've been discussing. So if you're ever wondering why it is that somebody is insisting that you give them some promise in the form of an indemnity, well, now you know why.
Okay, so for the first time in contract conversations, we're going to try and sort of issue a quick poll just with a couple of questions to try and consolidate what we've discussed. So I'm hoping that will pop up on your screen now. Don't worry, the answers to this they're not being recorded, and the end results won't pop up saying that attendee A answered X, Y, and Z. Probably relevant for you is for question 6. I've just put the clause which is relevant there to question 6. Appreciate that some people might be joining on smartphones or on tablets, and that the poll might not necessarily pop up there. So I'll just read out the questions just for their benefit, and then we'll just quickly run through the answers. So the first question is, if the parties title a term a condition in a contract, will the courts construe that as a condition, true or false? The second one is, which of these statutory obligations are implied as conditions? The right to title from the seller when they're selling goods, or the stipulation as to time for the payment of goods. The third question is, if a condition is breached, what can the innocent party do? And then there's 3 options of either just claiming damages, repudiating the contract, or thirdly, repudiating the contract and claiming damages. In respect to the fourth question, that is a warranty a term which is a representation, a fundamental term which goes to the root of the contract, or a minor term? And then the fifth question is, if you're dealing with an indemnity, do you have to worry about whether or not your losses are too remote when you're claiming under that indemnity? And then the sixth question, is there is an example clause there on the slide from a recent case called Arc Shipping. And I appreciate that you haven't got all the factual background of what happened in that case. But basically, it's just a question of just how do you think that the court came out with that particular provision? Did it consider that to be a condition, an innominate term, a warranty, or an indemnity? And so if we just quickly run through the answers. So in respect to the first question there about if the parties title a term a condition, it's false. The courts won't necessarily construe that as a condition just because the parties have termed it a condition. In respect to the second question there about statutory obligations which are implied, that's the right to title of the sale of goods from the seller. That will be implied as a condition under the Sale of Goods Act. In respect to the third question of if a condition is breached, what can an innocent party do? Well, they can repudiate the contract and claim damages. So I've just seen that the results have now popped up on the screen. So most people have got them right so far. And so, yeah, so within a warranty is a term which is a minor term of the contract. In respect of the fifth question there about indemnities, that's correct. You don't have to worry about whether losses are too remote when claiming under an indemnity. And I think people have sort of followed what Eric and I were saying in respect of the sixth question there about what the clause was in ARC shipping, that sort of courts are sort of coming down to the view now that the majority of clauses will be innominate terms unless you can satisfy using that test in SPA shipping that it should be treated as a condition or a warranty. So we'll quickly just deal with questions that we've received.
Okay, one question here, isn't hold harmless different to an indemnity? Whilst an indemnity would reverse the burden of proof, a hold harmless provision says that the indemnifier will not blame the beneficiary if the beneficiary has caused or contributed to the loss. So there's potentially an impact on contributory negligence and possibly on gross negligence or willful or deliberate acts. I think the answer is that when you say hold harmless provision, you probably have in mind a particular hold harmless provision or sort of hold harmless agreement, and it is true that you can draft for whatever it is you want. So in that sense, you know, if the particular provision that you're referring to there, the hold harmless provision you're referring to, is drafted in the way that you described, then it will have that effect. What I was sort of just referring to when I was talking about indemnities was just the kind of basic concept of an indemnity, which is that it's a primary obligation. Somebody is assuming a primary obligation to effectively do whatever it takes to ensure that you don't suffer the loss. So if it's not qualified in the kinds of ways that you're describing, then the effect of the indemnity will mean that you don't have to get over these burdens of having to show that the loss isn't too remote, etc. Hope that helps. If I'm not clear, then by all means drop me an email and we can talk about it some more. Shall I do the next one, Mark?
Yeah.
I've got quite a few here. As a matter of good practice, when acting for a party giving an indemnity, would you always try to make the indemnity subject to the overall cap on liability under the contract? Yes, I think so. If you don't, then I think the issue there is you may need to, if you want the cap to apply to the indemnity, then you may need to insert some special words into either the cap or the indemnity to make that clear. Because if you just rely on the general cap that you have in the contract, it may be worded in a way that the cap only applies to damages. And technically, as I was describing, a claim under an indemnity isn't a claim for damages, it's a claim to enforce the primary obligation under the agreement rather than a claim for damages to compensate for the breach of a primary obligation. So if your cap only applies to damages, then it may not cap your indemnity unless you actually put in some words to say so. So hopefully that helps. Next question here is a contractual representation of fact usually an innominate term? Bit hard to say in the abstract, but I think probably yes, because if you've got some clause in your contract which is making some kind of representation of fact, which the other side is relying on, then that is unlikely to be a condition, I would say, probably, unless it's really clearly something which is totally central to the that really goes to the heart of the bargain between the two parties, or unless it has
a description of the quality of goods, Eric, under the Sale of Goods Act as well would be a good example.
That would be a good example, yeah, and that's an example of where by statute the representation of fact would be deemed to be a condition. But unless that falls within one of those provisions of the Sale of Goods Act as a condition, or unless it's like really essential to the bargain, it's probably unlikely to be treated as a condition. And then it's also unlikely, most most other terms that are not conditions fall into this basket of innominate terms, where you can only terminate depending on the seriousness of the particular breach of the term. So the answer is probably an innominate term, unless it's a condition, unless it's by statute deemed to be a condition, or unless it's a very important term to the bargain between the parties. Gosh, we've got quite a few. Probably, you've got any more time to do a couple more, Mark? Are there any you can do?
There's one there just about, can you explain the significance of a representation, please? And I think we should have probably done that, but it's, I suppose there is the representation that might be made within the contract itself. I suppose there is a separate issue there of, and hopefully this is what the attendee's getting at, is on representations prior to a contract that may have acted to induce somebody to enter into the contract. And that will be dealt with separately under the, if there is a misrepresentation, under the Misrep Act. But also just be conscious of the entire agreement clauses, which you usually see in commercial agreements, where parties try and exclude prior representations which were made prior to the contract being entered into.
Somebody's asked, does a negligence carve-out preclude an indemnity being treated as such? I think that probably depends. It's sort of similar to the question, the answer I just gave about the liability cap. It kind of depends on the wording of your negligence carve-out and whether it extends to claims under indemnities as well as claims for damages, because if it doesn't, then it may not apply to the indemnity, but if it's expressed broadly enough, it will. I hope that helps. Somebody else has asked, generally speaking, how do limitation of liability clauses interface with indemnity clauses? Well, that's like the question that Naomi asked. So it depends on the wording of your limitation of liability clause and whether or not it extends to claims under indemnity as well as claims for damages. In practice, do indemnities result in a much higher recovery than a claim for damages? Can you estimate a percentage for this? They're more straightforward to pursue because, as I was describing, there are just a few hurdles that you don't have to jump over. Instead, you can skip past them. So for that reason, claimants prefer them. And so they're easier. There are less defences in the defendant's toolbox. So your chances of succeeding in making a recovery, if you have to go to court, are higher. Your chances of getting a settlement are higher. The chances of the settlement being higher than it would otherwise be are higher. And also the kinds of losses that can be within the scope of the indemnity are limited in the same way as a damages claim. So basically the court gets to control what kinds of damages are available to compensate you for a breach of a term of a contract. And so the court gets to kind of regulate that and decide what kinds of things are in and out. Whereas when you're dealing with an indemnity, it's purely a creature of contract as to what's within the scope of the indemnity or not. And so you can define whatever loss you like. So you have the opportunity there to throw the net wider and capture more kinds of loss. So for that reason, you may make a higher recovery when you're suing under an indemnity than you otherwise would, because the indemnity might cover a greater scope of loss than would be covered by a damages claim. It might, for example, cover your costs of having to enforce the indemnity claim, whereas you probably won't be able to recover that as part of your damages claim. You instead have to let the court decide whether or not you're entitled to your costs, and they may well not let you have all of your costs, whereas you may be able to get all of your costs under an indemnity, for example. Okay, I think we've probably reached the limit of our time for today. I can see there's quite a few more questions there which we haven't got to, so we will follow up follow up with the people who have asked these questions separately afterwards. But I would just like to say thank you very much for coming this afternoon. It's great to have so many of you come. Next contract conversation in a fortnight's time, we're going to be covering litigation funding and the kinds of third-party funding arrangements that are available now to claimants to pursue contract claims and other kinds of litigation. So I hope you can join us for that in a fortnight's time. It should be a really good and interesting one. Thank you very much for coming.